Do you think that the Senate has a constitutional obligation to take this up, to vote?
We think that it's quite clear in the Constitution that when there's a vacancy, the president proposes a nominee, and then we think that, as has been the practice for decades, in fact centuries in the Senate, that advise and consent means meetings, public hearing, where that judge, in this case Judge Garland, is willing to go under oath on national television and answer their questions, and then a vote in the committee and a vote in the Senate. That's what should happen here.
But the Washington Post did a fact check, a historical fact check. They actually gave that idea that there's a constitutional obligation 3 Pinocchios. They said, first of all, the Constitution says nothing about vote. It simply says advice and consent before a confirmation. And secondly, there has been a long history, mostly in the 19th century, that the Senate has decided not to act in a number of cases.
Look, Chris, we don't need to jump back to the 19th century, the 1800s, right? We're here in the 21st century. What we ought to do is look at the precedent over the course of these last many decades. And as was the case when Vice President Biden was the chairman of the committee, every nominee got a hearing, got meetings, got vote in committee, and got a vote on the floor. This is not difficult. This is the way it operates in the Senate, and they ought not reach back to the precedents of the 1800s. Let's just do the way they've been doing it for a long, long time.
As we discussed,